Good morning, sir. Are you Germaine Duhan? And Mr. Lewis, will your client waive the formal reading of the indictment? Mr. Duhan, in cause number 24 DCCR 2464, the state's elected to proceed on count 1 only. It alleges you committed the third-degree felony offense of obstruction or retaliation. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? And do you fully understand? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up your right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from remission of the country, or denial of naturalization of law?
Boom. 5 years in state prison for obstruction and retaliation. Notice how the judge immediately mentions firearm restrictions. That's because a felony conviction automatically strips away gun rights in Texas. Quick question. Should all felons lose their gun rights? Or should it depend on the crime? What do you think?
State tenders number 1. Submitted. Is there any evidence that Mr. Duhan is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. And at this time, find you guilty of the third-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws, make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to me. Alright, good luck to you, sir. You can go back with the law. Thank you, Mr. Lewis. Good morning, Mr. Christopher Bushnell. So, Mr. Bushnell, you were previously in court.
21 incident reports at just 17 years old. Fights, bullying, stealing food, and let's not forget he's tied to organized crime. If he can't follow rules behind bars, what are the chances he'll stay clean on probation? Honestly, would you give him another shot or lock him up to protect the community?
Or enter pleas of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and the second-degree felony offense of engaging in organized criminal activity. Those were for agreements of a 10-year probation deferred in each of those cases. I have received the pre-sentence report. Has everyone had an opportunity to review those? Are there any additions or corrections to the report?
I think that was waiting to go to court locally that should be going to take for something for this action.
I've also reviewed jail incident reports. Have you both been given a copy of those?
Yes,
So you're 17 now? September 20.
everything to go back, negotiate all that. Do that. You know.
Well, and I'm
I have to do because they don't want me to have the opportunity. You just like to be able to have to not want to adulthood. So it's cheap. I had reached down the importance of all people.
and you can't do it. Can you? You cannot. 21 incident reports since January 25th of this year. 21. fighting, calling officers' names, stealing food, instigating fights, being a bully to other people in the dorm. Ridiculous. So if you can't follow rules in the jail, what makes you think you're going to come in here and I'm going to say, sure, go be on probation out in our community? After y'all shot guns, I mean, this is serious.
And there it is. The deal is dead. The judge just rejected probation, warning Bushnell that his record could land him up to 20 years in prison. This is the turning point. No more easy outs. From here, every move he makes could seal his fate.
I'm tired of the shootings. I'm tired of people. You could have killed somebody. And because you accidentally didn't kill somebody, you get to get a probation. Not today. If I could send you to ISF, I would consider it. Can't. At this point, I'm going to reject the plea agreement. We will set the cases for a review in about 30 days. Let's see where we are. Go over his options. Y'all talk. If I can always do, upfront time, but we've got to get to a certain point where that would make sense. So at this time, I'm just going to reset the cases. Again, I'm rejecting the plea agreement. And let me tell you, if you get more of these, it's only going to get worse. I'm going to see them. Jury's probably going to see them if you, not probably, a jury will see them if you go to trial. And you're going to end up in prison for up to 20 years because you can't follow the rules in our jail and you're acting like a little punk. So go stop acting like a punk, prove that you can behave, then we'll see what happens when you come back next. I'll see how many of these I have. Go back with the bailiff. Mr. Blunt, you're on probation for an extremely serious offense. I could be sending you to prison today for a very long time for violating your probation. Sounds like probation's willing to work with you. You've done some positive things while you're on probation, which are good, that you are going to treatment. You've made a great deal of progress. Those are the things that I'm really concerned about, but they're not the only things I'm concerned about. You've got to follow all of the rules, not just some of them. You've got to get this drug deal kicked. If you don't, you're going to go to prison over drugs instead of really what you are, the underlying offense is. Do you understand? We're going to give you the opportunity. We're going to give you treatment. You take advantage of it and change that part of your life. Great. If you don't, you're back in here, and it's going to be zero tolerance. There's no messing up at this point. Do you understand? If the treatment that you're getting through JCDI is not enough, it's going to be up to you to be a grown-up and go to probation and say, I'm feeling tempted, I need more help. Nobody wants to go into custody for more help, but it's better to go in for 90 days than it is to go to prison for up to 20 years.
Interesting twist. Unlike Bushnell, Blunt gets another chance. Instead of prison, the judge orders him into 2 rehab programs, one for decision-making and one for drug recovery. It's a last-ditch effort to save him from 20 years behind bars. Do you think tough love works better than locking people up? Or is this just delaying the inev?
Right? Okay. So in clause number 15-21380, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the recommendation of the district attorney and probation and continue you on probation in order that you enter and successfully complete the cognitive track of the ISF program. And then when you're released, you will enter and successfully complete the JCDI program. These programs are doing 2 different things. The first one is to help you make better decisions. It's about thinking and making better decisions. The JCDI program is the drug intervention program to help you with what you need, hopefully, to stop using drugs. So you're going to have all the tools that you need to make these better decisions. Then it's going to be up to you. Continue doing everything you're supposed to through treatment and other things like that. It sounds like that hasn't been an issue. You're still on a deferred probation. You're still not convicted of this offense. If you're back in here again, in all likelihood, you will be convicted and you will be going to prison for a very long time. Do you understand? All right. Good luck to you, sir.
Thank you.
Good morning, sir. You're Lawrence Marr? And in cause number 24, DCCR 1763, Mr. Marks is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I make a new law. Shooting against her. Whereas for recent, just offer.
All right. Okay, so I'll do one last reset. We will get an announcement, make sure, go over everything with Mr. Marks. Mr. Marks, when Ms. Peraza comes to visit with you, she'll give you all your options, show you everything, and then we'll get an announcement at the next court date, whether or not it's going to be a plea or a trial. Okay?
What I'm stating is
Okay, perfect. Perfect. All right, thank you, sir. You can get back with the bailiff.
thank you.